Most cybersecurity videos talk about protecting yourself from hackers. This one is about something a little different, the actual law that defines what hacking legally means in the United States. A law that is almost 40 years old and somehow still governs some of the most advanced cybercrime cases happening right now. Welcome to Cyber Safety Brief, where we explain simple cybersecurity advice for everyday Americans. Before we go further, here is something important. This video is based on authentic, legal, and publicly available cybersecurity information. Everything here is for awareness and understanding only. I am not going to explain how to hack anything. I am going to explain how the law that punishes hacking actually works, and honestly, how confusing and outdated parts of it still are. Here is what I am not going to do in this video. I am not going to give you a boring legal timeline that puts you to sleep. What I am going to do is show you why a law written in 1986, years before most people had ever used the internet, still shapes some of the biggest cybersecurity and cybercrime cases in America today, and why legal experts across the political spectrum have been asking Congress to fix it for decades. Let's start with a question. Have you ever shared a Netflix password with a friend? Have you ever used a coworker's login because yours was not working that day? Have you ever kept using a company account for a few days after you technically left the job? In my opinion, most people have done at least one of these things without thinking twice about it. And in my opinion, that is exactly why this law matters to you, because depending on how you look at it, some of these everyday actions technically brush up against the edges of a federal hacking law. Point 1. Where the CFAA actually came from. Let's talk about the origin story first, because it explains a lot about why this law is written the way it is. The Computer Fraud and Abuse Act was passed by Congress in 1986. At the time, computers were still relatively new in most households and businesses. There was no World Wide Web yet. What existed instead were early computer networks, mostly used by government agencies, universities, and large corporations. Congress was responding to growing public anxiety about computer crime, an anxiety that had actually been fueled partly by pop culture. The movie War Games, released in 1983, showed a teenager accidentally hacking into a military computer system and nearly triggering a nuclear war. That film reportedly influenced lawmakers, including President Reagan himself, who apparently asked his advisors after watching it whether something like that could really happen. Here is the part that surprises people. Before the CFAA, there was no clear federal law specifically addressing unauthorized computer access. Prosecutors were stuck trying to apply older laws, things designed for mail fraud or property theft, to crimes that did not really fit those older categories. The CFAA was meant to close that gap by creating a law specifically built around computers. What I personally think is that the original 1986 version of the law was actually fairly narrow and reasonable for its time. It focused mainly on protecting government computers and financial institution systems from unauthorized access. The core idea was simple: accessing a computer system without authorization or exceeding authorized access could be a federal crime, especially when it involved sensitive government or financial systems. But here is where things start to get complicated, and this is the real-life pattern that has played out over decades. As computers became part of everyday life, Congress kept expanding the CFAA through multiple amendments, broadening its scope again and again. By the time these amendments were finished, the law no longer just covered government and banking systems. It covered essentially any computer connected to the internet, which today means almost every computer on Earth. In my opinion, that is the single most important thing to understand about the CFAA. A law originally designed for a small number of specific sensitive systems in the 1980s now technically applies to nearly every device connected to the internet in your home right now. It is worth walking through a few of these amendments briefly, because each one tells its own small story about the fears of its era. In 1994, Congress added a civil remedy, meaning companies and individuals could sue for damages under the CFAA, not just rely on criminal prosecution. This turned the law into something businesses could use directly in private lawsuits, not just something prosecutors used in criminal cases. In 1996, the definition of a protected computer was expanded significantly, moving away from narrowly defined government and financial systems toward any computer used in interstate commerce, a phrase that courts have since interpreted extremely broadly, given that almost any computer connected to the internet technically involves interstate and often international data transmission. Then came the USA Patriot Act in 2001, passed in the aftermath of the September 11th attacks, which further expanded the CFAA's reach and increased penalties, reflecting the broader national security anxiety of that period. In my opinion, this pattern, where major cybersecurity legislation expands significantly after a moment of national fear or crisis, is not unique to the CFAA. We have discussed similar patterns on this channel with other laws. But the CFAA is a particularly clear example because you can trace its growth almost decade by decade, each expansion tied to a specific cultural or political moment rather than a single, coherent, forward-looking plan for how computer crime law should actually work. Point 2. What unauthorized access actually means and why that's the problem now. Let's get into the part of this law that causes the most confusion and, honestly, the most controversy among lawyers and judges themselves. The CFAA makes it illegal to access a computer without authorization or to exceed authorized access. That sounds simple on paper. In practice, courts across the country have interpreted those exact same words in dramatically different ways, and that inconsistency has created real legal chaos. Here is a real-life example that shows exactly how messy this gets. Imagine an employee who has permission to access a company database for work purposes, but who uses that same access to look up information for a personal reason unrelated to their job, maybe checking a friend's account out of curiosity. Did that employee exceed authorized access under the CFAA, turning a workplace policy violation into a potential federal crime? For years, different federal appeals courts around the country genuinely disagreed on the answer. Some courts said yes, arguing that violating the purpose behind the access counts as exceeding authorization. Other courts said no, arguing that if you had legitimate technical access to the system in the first place, misusing that access for a bad reason is a policy violation, not a federal hacking crime. What I personally think is that this exact disagreement shows how badly this law has aged. A law meant to stop malicious outsiders from breaking into protected systems has, in some interpretations, been stretched to potentially cover employees who simply misuse access they were already given. In my opinion, that is a massive difference in seriousness, and treating both situations the same way under one broad federal statute never made much practical sense. This tension eventually reached the Supreme Court. In 2021, the Supreme Court decided a case called Van Buren versus United States, involving a police officer who had legitimate access to a law enforcement database for his job, but who used that access to look up license plate information in exchange for money, a clear misuse of his job-related access, but not a technical break-in of any kind. The Supreme Court ruled in his favor, adopting a narrower interpretation of exceeds authorized access. The court essentially said that if you are technically allowed to access certain files or areas of a system, using that access for an improper reason does not automatically turn into a CFAA violation. In my opinion, this ruling was a genuinely important moment because it pulled back some of the broadest, most aggressive interpretations of the law that had been building for years, interpretations that critics had long warned could criminalize routine workplace behavior. It is also worth understanding how severe CFAA penalties can actually be, because the range is genuinely wide depending on the specific violation. A first-time, relatively minor offense might carry a sentence of up to 1 year. But more serious violations, especially those involving significant financial loss, damage to critical infrastructure, or repeat offenses, can carry sentences of 10 years or more per count, and prosecutors can often bring multiple counts within a single case. In my opinion, this sentencing structure is exactly why the vagueness around authorized access matters so much practically. when the same ambiguous legal language can result in anything from a minor fine to a decade in federal prison depending on how a prosecutor chooses to charge the case, that ambiguity becomes a genuinely serious problem, not just an academic one. There is also an important distinction worth understanding between the CFAA's criminal provisions and its civil provisions. Because the law allows private lawsuits, companies have used the CFAA in civil court against former employees, business competitors, and even individuals who scraped publicly available data from websites in ways the website owner did not like. This has led to some genuinely strange applications of the law, including lawsuits over things like automated data collection from public web pages, cases that arguably have very little to do with the kind of serious computer intrusion Congress originally had in mind back in 1986. Point 3. How this law applies to real cybercrime today. This is the part I think really matters, because so far this might sound like a legal technicality debate that has nothing to do with actual cybersecurity threats. It absolutely connects. Here is what most people underestimate. Despite its age and its flaws, the CFAA remains the primary federal law used to prosecute serious hacking crimes in the United States. When federal prosecutors bring charges against someone for breaking into a company's network, stealing data, deploying ransomware, or running large-scale fraud schemes involving computer systems, the CFAA is very often the core charge, sometimes alongside other laws like wire fraud or identity theft statutes. In my opinion, this dual nature of the CFAA, being both outdated in some respects and still critically important in practice, is exactly why understanding it matters. On one hand, the law has been criticized for decades for being vague and overly broad in ways that could theoretically criminalize minor, non-malicious behavior. On the other hand, it remains a genuinely essential tool for prosecuting serious, damaging cybercrime that harms real victims, real companies, and real critical infrastructure. Let me know in the comments if you agree with this, because I think a lot of people assume there must be some newer, more modern law specifically written for today's cybercrime landscape, when in reality, prosecutors are still primarily relying on a heavily amended version of a law that started in 1986. Let's make this a little more concrete with an example. Ransomware attacks, one of the most damaging forms of modern cybercrime, are frequently prosecuted under the CFAA when the attackers can be identified and are within reach of U.S. law enforcement. The law's core prohibition against unauthorized access and its provisions covering damage to computer systems apply directly to how ransomware operates, gaining unauthorized entry into a network and then encrypting or damaging data. So, even though ransomware as a concept did not exist when this law was written, the broad language Congress used has allowed prosecutors to apply it to threats that did not exist in 1986 at all. Point 4. The controversial cases that shaped public debate. I want to talk about a few specific cases here because they explain why this law has been so controversial for so long and why reform efforts keep coming up in Congress without ever fully succeeding. One of the most well-known and tragic cases involved a young programmer and internet activist named Aaron Swartz. In 2011, Swartz was charged under the CFAA after downloading a large number of academic articles from a database through MIT's network, using automated scripts in a way that arguably violated the terms of service of the platform he was accessing, though he had legitimate access to the university's network itself. Federal prosecutors pursued the case aggressively, and Swartz faced the possibility of decades in prison and massive fines. He died by suicide in 2013 while the case was still pending. His death sparked intense public debate about whether the CFAA's penalties were wildly disproportionate to the actual harm caused, and whether prosecutors had used the law's broad language to pursue an unreasonably harsh case against someone who had not caused the kind of serious damage the law was originally meant to address. What I personally think is that this case, more than almost any other, exposed the core problem with how broadly the CFAA can be applied. Downloading academic articles, even in a way that violated a website's terms of service, is a fundamentally different kind of act than breaking into a bank's financial systems or stealing someone's personal data for profit. Yet, under the CFAA as it existed and was being interpreted at the time, both could potentially fall under the same broad statute, with prosecutors having enormous discretion over how aggressively to pursue a case. Another important pattern worth understanding involves security researchers. Ethical hackers and cybersecurity researchers often test systems for vulnerabilities, sometimes without explicit prior authorization, in order to responsibly disclose security flaws to companies so they can be fixed before malicious actors find them first. For years, this created genuine legal uncertainty. Was a security researcher who accessed a system without formal permission purely to find and report a vulnerability, committing a federal crime under the CFAA, even if their intentions were entirely good and they caused no actual harm? In my opinion, this uncertainty had a real chilling effect on legitimate security research for years, because researchers genuinely did not know whether their good faith work could expose them to criminal prosecution. The Van Buren decision we discussed earlier helped narrow some of this uncertainty, and the Department of Justice has since updated its own internal charging policies to state that it generally will not prosecute good faith security research conducted for the purpose of finding and fixing vulnerabilities. In my opinion, this is a positive development, but it is important to understand that this is a policy choice by prosecutors, not a permanent change to the law itself. A future administration could theoretically choose to interpret and enforce the CFAA more aggressively again, since the underlying statute has not been fundamentally rewritten to formally protect this kind of research. Another case worth mentioning briefly is the long-running legal battle between a company called HiQ Labs and LinkedIn, which centered on whether scraping publicly viewable data from a website using automated tools without the website owner's permission violates the CFAA. LinkedIn argued that once it blocked HiQ's access and sent a cease and desist letter, any further scraping became unauthorized access under the law. Federal appeals courts ultimately sided largely with HiQ, ruling that accessing publicly available information that does not require a password or login generally falls outside the CFAA's scope, since there is no meaningful authorization barrier to bypass in the first place when information is already open to the public. In my opinion, this case matters because it drew an important line between two very different things that often get confused: breaking into a genuinely restricted system and simply collecting information that was already publicly visible, even if a company would prefer you not collect it in bulk. Point 5. What this actually means for regular people here is what most people underestimate about all of this. You almost certainly interact with systems covered by the CFAA every single day, and understanding roughly where the legal lines currently sit is genuinely useful, not just academic. Sharing a streaming service password with a friend, in most currently understood interpretations post-Van Buren, is unlikely to trigger CFAA liability on its own, since this generally falls under a civil terms of service violation, rather than unauthorized computer access in the criminal sense. However, this is exactly the kind of gray area that has been argued differently in different courts over the years, so the honest answer is that the boundaries are not as crisp as most people would like them to be. Using an old employer's login credentials after leaving a job is a much clearer example of the kind of behavior that can trigger real CFAA liability, since that access was never authorized after employment ended. In my opinion, this is one of the more practical, everyday takeaways from understanding this law. If you leave a job, using any lingering access to old systems, even out of simple convenience or forgetting to log out somewhere, carries genuine legal risk that most people do not think about. Point 6. Practical steps you can actually take. So what can you, as a regular person, actually do with this information? Here are some genuinely practical, defensive steps. First, understand that authorization is the entire legal foundation of this law. If you are ever accessing a system, account, or network that you know you are not currently supposed to have access to, whether that is a former employer's systems, an account you were removed from, or a system you found a way into without permission, stopping immediately is the safest choice, regardless of your intentions. Second, if you work in any role involving computer systems, take your employer's acceptable use policies seriously, not because violating them always leads to federal prosecution, but because these policies often define exactly where the legal line for authorized access sits in the eyes of a court. Third, if you are a security researcher or someone interested in that field, familiarize yourself with responsible disclosure practices and current Department of Justice guidance on good faith research. In my opinion, coordinating directly with a company through an official bug bounty program or responsible disclosure channel, rather than testing systems independently without any communication, is the safer and more professionally respected path. Fourth, as a business owner or manager, clearly documenting who has authorized access to which systems and promptly revoking that access when someone leaves a role is not just good cybersecurity hygiene. It is also what gives the CFAA its actual legal teeth if your systems are ever genuinely breached, since clear documentation of unauthorized access makes prosecution significantly more straightforward. Fifth, stay aware that CFAA reform remains an ongoing conversation in Congress. In my opinion, given how much technology has changed since 1986, and even since the law's last major amendments, continued pressure for modernization is likely to keep resurfacing, especially as AI-related computer misuse raises entirely new questions this law was never designed to anticipate. Point 7. Why reform keeps stalling. Before I wrap up, I want to address something honestly because I think it is the most useful question a viewer could ask at this point. If this law is this widely criticized, why hasn't Congress simply rewritten it? In my opinion, the answer connects to a pattern we have discussed on this channel before with other cybersecurity laws. Reforming the CFAA requires balancing two competing priorities that are genuinely difficult to satisfy simultaneously. Prosecutors and law enforcement generally want to preserve broad language, arguing that narrowing the law too much could create loopholes that sophisticated cybercriminals could exploit. Civil liberties advocates, security researchers, and many legal scholars generally want much narrower, more precisely defined language, arguing that broad language creates exactly the kind of prosecutorial overreach that happened in cases like Aaron Swartz's. What I personally think is that the Van Buren decision represents the most significant reform this law has seen in years, but it came from the judicial branch interpreting existing language, not from Congress actually rewriting the statute itself. That distinction matters because judicial interpretations can shift again with future cases, while a clear legislative rewrite would provide more lasting certainty. Several formal reform bills have been introduced in Congress over the years, specifically aimed at clarifying the CFAA's language, but none have successfully passed into law, largely due to the same kind of competing priorities gridlock that affects so much other cybersecurity and technology legislation in the United States. I would also like to know your opinion. Do you think the CFAA needs a complete legislative rewrite to match today's technology? Or do you think the current mix of court interpretations and prosecutorial discretion is a workable enough solution? I am genuinely curious what people think, because this is one of those topics where even legal experts who agree on almost everything else in cybersecurity policy tend to land in very different places. If this video helps you understand online safety more clearly, like the video and subscribe to Cyber Safety Brief for more simple cybersecurity advice. Here is the honest summary. The CFAA was written in 1986 in direct response to early public fears about computer crime, partly inspired by a Hollywood movie, and it has been amended repeatedly since then, through the 1990s and after the September 11th attacks, to expand its reach far beyond its original narrow focus on government and financial systems. Its core language around unauthorized access has been interpreted inconsistently by courts for decades, leading to genuinely controversial prosecutions like the Aaron Swartz case and real uncertainty for security researchers and companies scraping public data alike, until the Supreme Court's 2021 Van Buren decision narrowed some of the broadest interpretations. Despite its age and its flaws, it remains the primary federal law used to prosecute serious hacking and cybercrime in America today. That is not meant to scare you. It is meant to help you understand that a law written before most people had ever touched the internet is still quietly shaping what counts as a federal crime every single time you log into a computer system today. Stay alert, stay informed, and stay safe online. Before you go, comment below which part of this law surprised you the most.